Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking
So
of who works.
are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember. Yeah. How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
right,
please
I'm not
answer
sure.
the question.
I'm just trying to think. Do I know anyone who works at that firm? I might know.
Have you had? That's not my question. My question is, have you had a conversation with anyone at that firm about that investigation? It's a really specific question.
I would like to know the person you're thinking of, because what if there's?
I think you're thinking of someone and you don't want to tell us. Who did you have a conversation with at that?
I'm not going to...
Mr. Chairman, I'd like to raise an objection here. This town is full of law firms. Law firms are full of people.
First of all, I'd like you to pause the clock. Thank you.
The clock is paused.
Thank you.
Pause the clock. Let me raise my objection.
Recognized.
This town is full of law firms. Law firms are full of people. Law firms have a lot of names. There are a lot of people who work at a lot of law firms.
Responsibility to all Americans. Vote no. Be a hero. Vote no. You have a responsibility to all Americans. Be a hero and vote no.
And
be a hero and vote no. Be a hero and vote no. You have a responsibility to all Americans. Be a hero and vote no.
Senator Lee.
on that point, law firms abound in this town, and there are a lot of them. They're constantly metastasizing. They break off. They form new firms. They're like rabbits. They spawn new firms. There is no possible way we can expect this witness to know who populates an entire firm that he's not even...
I see Senator Graham has rejoined us. I think he was here before me. He's more senior. Okay, great. So I thank you, Mr. Chairman. I'd like to restate my objection from earlier for the record, which is my motion to postpone this hearing. A number of comments have been made by my honored and respected colleagues. I'd like to address a few of them. One, there was some mention of a concern about Elena Kagan's hearing, and that the White House at the time, there was an agreement that those certain records are sensitive and should therefore not be disclosed. It's my understanding that as a point of distinction between that time and today, that those were active cases in the White House, and for that reason there was an understanding and agreement that they were of a sensitive nature and should not be disclosed. In terms of the point that has been made about playing politics and blaming the Supreme Court, I think that we have to give pause when those kinds of concerns are expressed to also think about the fact that there have been many a political campaign that has been run indicating an intention to use the United States Supreme Court as a political tool to end things like the Affordable Care Act, the Voting Rights Act, and campaign finance reform, which makes this conversation a legitimate one in terms of a reasoned concern about whether this nominee has been nominated to fulfill a political agenda as it relates to using that court and the use of that court. As it relates to the 42,000 documents, or 42,000 pages of documents, I find it interesting that we get those documents less than 24 hours before this hearing is scheduled to begin. But it took 57 days for those documents to be vetted before we would even be given those documents. So there's some suggestion that we should be speed readers and read 42,000 pages of documents in about 15 hours, when it took the other side 57 days to review those same documents. So the logic, at least on the math, is not applying. Now, the chairman has requested 10% of the nominee's documents. That's 10% of 100% of his full record. The nominee's personal lawyer has only given us 7% of his documents, 7 out of 100% of the full record. Republicans have only given 4% of these records or made them public. That's 4% of 100% of a full record. 96% of his record is missing. 96% of his record is missing. It is reasonable that we should want to review his entire record, and then we can debate among us the relevance of what is in his record to his nomination. But it should not be the ability of the leadership of this committee to unilaterally make decisions about what we will and will not see in terms of its admissibility, instead of arguing about the weight of whatever is made admissible. The late Senator Kennedy of Massachusetts called these hearings a Supreme Court nominee's, quote, job interview with the American people. And by that standard, the nominee before us is coming into his job interview with more than 90% of his background hidden. I would think that anyone who wanted to sit on the nation's highest court would be proud of their record and would want the American people to see it. I would think that anyone privileged to be nominated to the Supreme Court of the United States would want to be confirmed in a process that is not under a cloud, that respects due process. I would think that anyone nominated to the Supreme Court of the United States would want to have a hearing that is characterized by transparency and fairness and integrity and not shrouded by uncertainty and suspicion and concealment and doubt. We should not be moving forward with this hearing. The American people deserve better than this. So Judge Kavanaugh, as most of us know, and I will mention to you, and you have young children, and I know they're very proud of you, and I know you are a great parent, and I applaud all that you have done in the community. And so as you know, as we all know, this is a week when most students in our country go back to school. And it occurs to me that many years ago, right around this time, I was starting kindergarten. And I was in a school bus, on my way to Thousand Oaks Elementary School as part of the second class of students as busing desegregated Berkeley, California public schools. This was decades after the Supreme Court ruled Brown v. Board of Education that separate was inherently unequal. And as I've said many times, had Chief Justice Earl Warren not been on the Supreme Court of the United States, he could not have led a unanimous decision, and the outcome then of that case may have been very different. Had that decision not come down the way it did, I may not have had the opportunities that allowed me to become a lawyer or a prosecutor. I likely would not have been elected District Attorney of San Francisco or the Attorney General of California. And I most certainly would not be sitting here as a member of the United States Senate. So for me, a Supreme Court seat is not only about academic issues of legal precedent or judicial philosophy. It is personal. When we talk about our nation's highest court and the men and women who sit on it, we're talking about the impact that one individual on that court can have, impact on people you'll never meet and whose names you will never know. Whether a person can exercise their constitutional right to cast a ballot, that may be decided if Judge Kavanaugh sits on that court. Whether a woman with breast cancer can afford health care or is forced off life-saving treatment. Whether a gay or transgender worker is treated with dignity or may be treated as a second-class citizen. Whether a young woman who got pregnant at 15 is forced to give birth or in desperation go to a back alley for an abortion. Whether a president of the United States can be held accountable or whether he'll be above the law. All of this may come down to Judge Kavanaugh's vote. And that's what's at stake in this nomination. And the stakes are even higher because of the moment we're in, and many of us have discussed this, These are unprecedented times. As others have already observed, less than 2 weeks ago, the president's personal lawyer and campaign chairman were each found guilty or pleaded guilty to 8 felonies. The president's personal lawyer, under oath, declared that the president directed him to commit a federal crime. Yet that same president is racing to appoint to a lifetime position on the highest court in our land, a court that very well may decide his legal fate. And yes, that's essentially what confirming Judge Kavanaugh could mean. So it is important, more important, I'd say, than ever, that the American people have transparency and accountability with this nomination. And that's why it is extremely disturbing that Senate Republicans have prevented this body, and most important, the American people, from fully reviewing Judge Kavanaugh's record and have disregarded just about every tradition and practice that I heard so much about before I arrived in this place. Judge Kavanaugh, when you and I met in my office, you said, with respect to judicial decisions, that rushed decisions are often bad decisions. I agree with you. I agree with you. And when we are talking about who will sit on the Supreme Court of the United States, I believe your point couldn't be more important. Mr. Chairman, when Judge Kavanaugh was nominated in July, he expressed his belief that a judge must be independent, must interpret the law, and not make law. But in reviewing this nominee's background, I am deeply concerned that what guides him is not independence or impartiality. It's not even ideology. I would suggest it is not even ideology. What I believe guides him, and what his record that we've been able to see shows, is what guides this nominee is partisanship. This nominee has devoted his entire career to a conservative Republican agenda, helping to spearhead a partisan investigation into President Clinton, helping George W. Bush's legal team ensure that every vote was not counted in Bush v. Gore, helping to confirm partisan judges and enact partisan laws as part of the Bush White House. And in all of these efforts, he has shown that he seeks to win at all costs, even if that means pushing the envelope. And if we look at his record on the D.C. Circuit, and in his recent writings and statements, it is clear that the nominee has brought his political bias to the bench. He has carried out deeply conservative partisan agendas as a judge, favoring big business over ordinary Americans, polluters over clean air and water, and the powerful over the vulnerable. Just last year, Judge Kavanaugh praised the dissent in Roe v. Wade and ruled against a scared 17-year-old girl seeking to end her pregnancy. He has disregarded the Supreme Court precedent to argue that undocumented workers weren't really employees under our labor laws. We have witnessed horrific mass shootings from Parkland to Las Vegas to Jacksonville, Florida. Yet Judge Kavanaugh has gone further than the Supreme Court and has written that because assault weapons are, quote, in common use, assault weapons in high-capacity magazines cannot be banned under the Second Amendment. When he was part of an independent counsel investigation into the Democratic president, the nominee was dogged in demanding answers. And yet, he has since changed his tune, arguing that presidents should not be investigated or held accountable, a position that I am sure is not lost on this president. These positions are not impartial, they are partisan. Judge Neil Gorsuch, Judge Kavanaugh's classmate, insisted before this committee that judges are not merely, quote, politicians in robes. I fear that Judge Kavanaugh's record indicates that is exactly what he may very well be. Now, I know members of this committee and the nominee's friends and colleagues have assured us that he is devoted to his family and supportive of his law clerks and volunteers in his community, and I don't doubt that at all. But that's not why we are here. I'd rather that we think about this hearing in the context of the Supreme Court of the United States and the impact it will have on generations of Americans to come? And do we want that court to continue a legacy of being above politics and unbiased? Or are we prepared to participate in a process that is tainted and that leaves the American public questioning the integrity of this process? And I'll close by saying this. We have a system of justice that is symbolized by a statue of a woman holding scales, and she wears a blindfold. Justice wears a blindfold because we have said in the United States of America, under our judicial system, justice should be blind to a person's status. We have said that in our system of justice, justice should be blind to how much money someone has, to what you look like or who you love, to who your parents are and the language they speak. And every Supreme Court justice must understand and uphold that ideal. And, sir, should those cases become before you, Judge Kavanaugh, I am concerned whether you would treat every American equally or instead show allegiance to the political party and the conservative agenda that has shaped and built your career. I am concerned your loyalty would be to the president who appointed you and not to the Constitution of the United States. These concerns, I hope you will answer during the course of this hearing. I believe the American people have a right to have these concerns. I also believe the American public has a right to full and candid answers to the questions that are presented to you during the course of this hearing. I will be paying, of course, very close attention to your testimony, and I think you know the American public will be paying very close attention to your testimony. Thank you. Thank you.
You want to take over?
Judge, have you ever discussed Special Counsel Mueller or his investigation with anyone?
Well, it's in the news every day.
Have you discussed it with anyone?
With other judges, I know.
Have you discussed Mueller or his investigation with anyone at Kasowitz, Benson, and Torres, the law firm founded by Mark Kasowitz, President Trump's personal lawyer? Be sure about your answer, sir.
Well, I'm not remembering, but if you have something you want to...
Are you certain you've not had a conversation with anyone at that law firm?
Kasowitz, Benson.
Kasowitz, Benson, and Torres, which is the law firm founded by Mark Kasowitz, who is President Trump's personal lawyer. Have you had any conversation about Robert Mueller or his investigation with anyone at that firm? Yes or no?
Well, is there a person you're talking about?
I'm asking you a very direct question, yes or no?
I need to know I'm not sure I know everyone who works at that law firm.
I don't think you need to. I think you need to know who you talked with. Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking of who works.
Are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember. Yeah. How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
right,
please
I'm not
answer
sure.
the question.
I'm just trying to think. Do I know anyone who works at that firm? I might know.
Have you had? That's not my question. My question is, have you had a conversation with anyone at that firm about that investigation? It's a really specific question.
I would like to know the person you're thinking of, because what if there's?
I think you're thinking of someone and you don't want to tell us. Who did you have a conversation with at that time?
I'm not going to...
Mr. Chairman, I'd like to raise an objection here. This town is full of law firms. Law firms are full of people.
First of all, I'd like you to pause the clock. Thank you.
The clock is paused.
Thank you.
Pause the clock. Let me raise
The
my
Senator is
objection.
recognized.
This town is full of law firms. Law firms are full of people. Law firms have a lot of names. There are a lot of people who work at a lot of law firms.
You have a responsibility to all Americans. Vote no. Be a hero. Vote no. You have a responsibility
And
Be a hero and vote no. Be a hero and vote no. You have a responsibility to all Americans. Be a hero and vote no. Be a hero.
Senator Lee.
on that point, law firms abound in this town, and there are a lot of them. They're constantly metastasizing. They break off. They form new firms. They're like rabbits. They spawn new firms. There is no possible way we can expect this witness to know who populates an entire firm that he's not even. My point of order, Mr. Chairman, is simply this. If there are names, if there is a list of names he can be given of the lawyers to whom she's referring, I think that's fine. But I think it's unfair to suggest that an entire law firm should be imputed into the witness's memory when he doesn't know who works at the law firm.
Mr. Chairman, Mr. Chairman,
Senator Whitehouse,
we had
are you making a point of order?
well,
Senator Whitehouse,
I'm trying to figure out what the rules are here because we had a very, very long discussion about whether or not points of order were in order because this is a hearing. And we were told that all of our points of order,
Senator Whitehouse,
all the documents.
there's never been a time in the 2 days where someone's made an inquiry of the chair where the chair hasn't recognized the member for a point of inquiry or a point of order.
And I've been
was one
recognized
of
now,
them.
and I appreciate that. But my point is that if the rule is that nobody on our side can make a point of order, then it ought not to be appropriate for Senator Lee to start making points of order after all of ours were summarily
Senator White,
silenced on the basis that we were in a hearing and not in an executive session. If we've moved out of hearing and into executive session, then I'm more than happy to make motions.
Senator
to
Whitehouse,
adjourn.
if the mere fact that you're speaking right now means that you've been allowed to make a point of order, the matter that you're talking about yesterday was a motion that the chair said was out of order because it was an adjournment motion that would have required us to be in executive session. Anyone who want to make an inquiry of the chair may do so, but we will limit it to that before we go back to Senator Harris.
Very good. That's the right result.
Sir, please answer the question.
I don't know everyone who works at that law firm, Senator.
And have you had any discussion with anyone ever about Bob Mueller and/or his investigation?
So you said Bob Mueller, so have
Or
I ever
his-
had a discussion about Bob Mueller? I used to work in the administration with Bob Mueller.
What about his investigation? Have you had a conversation with anyone about his investigation?
I'm sure I've talked to fellow judges
Anyone aside from fellow judges?
about Bob Mueller.
About his investigation, sir? I'll ask again.
But-
I asked the question just a minute ago. I'm surprised you forgot. Have you had this conversation with anyone about the investigation that Bob Mueller is conducting regarding Russia interference with our election or any other matter?
The fact that it's ongoing, it's a topic in the news every day. I talked to fellow judges about it. It's in our, it's in the courthouse in the District of Columbia. So I guess
And I'll ask
the
you
answer to
one
that
last
is
time.
yes. So the answer is yes.
Okay, and did you talk with anyone at Kasowitz, Benson, and Torres?
You asked me that. I need to know who works there.
I think you can answer the question without me giving you a list of all employees of that law firm.
Well, actually, I can't.
Why not?
Because I don't know who works there.
So that's the only way you would know who you spoke with? I want to understand your response to my question, because it's a very direct one. Did you speak with anyone at that law firm about the Mueller investigation? It's a very direct question.
Right, I'd be surprised, but I don't know anyone, I don't know if I don't know everyone who works at that law firm, so I just want to be careful, because your question was and/or, so I want to be very literal.
That's fine. I'll ask a more direct question if that's helpful to you. Did you speak with anyone at that law firm about Bob Mueller's investigation?
I'm not remembering anything like that, but I want to know a roster of people, and I want to know more.
So you're not denying that you spoke with
Well,
anyone?
I said I don't remember anything like that.
Okay. I'll move on. Clearly, you're not going to answer the question. When you and I met, we talked about race relations in this country, and there's been a lot of talk among my colleagues with you about the subject. And when you and I met, I brought up the incident in Charlottesville, where, as you know, there was a rally by white supremacists that left a young woman dead. You will recall that the president who nominated you described the incident by saying, quote, "I think there is blame on both sides." So I think this will be a simple question for you. Do you, sir, believe there was blame on both sides?
Senator, we did talk, and I enjoyed our meeting, and to talk about the history of this country, and we talked about that at some length and talked about discrimination. I appreciated your opening statement yesterday where you talked about your experience. One of the principles I've articulated throughout this hearing is the independence of the judiciary.
And sir, I'd appreciate if you'd answer the question.
I am, Senator. So one of the principles I've talked about throughout this hearing is the independence of the judiciary. And one of the things judges do, following the lead of the Chief Justice and what all the judges do, is not stay out of current events, stay out of commenting on current events, because it risks confusion about what our role is. We are judges who decide cases in controversy. We're not pundits, or we don't comment on current events. We stay out of political controversy.
Judge, with all due respect, I only have limited time.
But it's,
Are you saying that it's too difficult a question, or it's a question you can't answer, which is whether you agree with the statement that there was blame on both sides? We can move on, but are you saying you cannot answer that pretty simple question?
I'm saying that the principle of the independence of the judiciary means that I can't insert myself into politics in either of two ways, commenting on political events or, in my view, commenting on things said by politicians, a governor, a senator, a congressperson, a president. I'm not here to assess comments made in the political arena, because the risk is I'll be drawn into the political arena, and the justices and judges of the United States.
And I appreciate your point. But there was such a robust conversation that happened, especially with my colleagues on the other side and you, about race. So on the subject of race, I raised this question, but we can move on. Have you ever heard the term, quote, racial spoils system?
Yes, and that is a term that sometimes is used to, yes, I've heard that term.
You twice wrote the term in the Wall Street Journal opinion piece describing the Cayetano case that you discussed previously with Senator Hirono. And I'll tell you, the racial spoil system, that term stood out to me, so I actually decided to look it up in the dictionary, the term spoils. And in the dictionary, spoils is defined as, quote, goods stolen or taken forcibly from a person or place. Can you tell me what the term racial spoils system means to you?
Senator, first of all, the Supreme Court affirmed the position that I had articulated in the amicus brief 7-2 in Rice versus Cayetano, an opinion written by Justice Kennedy. Second of all, the state voting restriction at issue in Hawaii was a state office, not for the Native Hawaiian.
Judge, that's not what I asked you.
But it
if you
didn't.
can define the term as you used it, what does it mean to you?
But I need to, you raised the case, and the state voting restriction in that case denied Hawaiians, residents of Hawaii, the ability to vote on the basis of their race. So if you were Latino or African American, you could not vote in the election.
And I heard your response to that earlier, and I appreciate the point that you made then. My question is, you used this term twice, and I'm asking, what does the term mean to you?
I'm not sure what I was referring to then, to be entirely frank. So I'd have to see the context of it. But what I do know is that the Supreme Court, by a 7-2 margin, agreed with the position articulated in the amicus brief, and that the voting restriction there was for a state office and denied people the ability to vote on account of their race. So it was.
Sir, I appreciate that, but you've been very forthcoming about the amount of work and preparation that you put into everything you do. You have certainly led me to believe that you're very thoughtful about the use of your words and your knowledge that words matter, especially words coming from someone like you or any one of us. And so I would like to know what you meant when you used that term, but we can move on, but I will say this. Are you aware that the term is commonly used by white supremacists?
Senator, when I wrote that was 20 years ago in the context of a voting restriction that denied African Americans and Latinos the ability to vote in Hawaii. That I was representing a client when I articulated that, and the answer to your question is no.
Okay. Well, unfortunately, it has been, and it is something that you should know. You should know that the same year you wrote your op-ed, a magazine published a cover story, a magazine that is described as being a white supremacist magazine, published a cover story about what it called, quote, the racial spoils system of, quote, affirmative action, the double standard in crime, sensitivity toward black deficiencies, and everything else. The same year, a self-proclaimed Eurocentrist wrote, quote, while blacks are generally regarded as the recognized expert in the game of racial shakedown, it is American Indians who may actually be the real geniuses at obtaining, quote, racial spoils. So we can move on, but my concern is that this is a loaded term, and it would be important to know that someone who may very well and very possibly serve on the United States Supreme Court would be aware that the use of certain terms will have a profound meaning because they are loaded and associated with a certain perspective and sometimes a certain political agenda.
Well, I take your point. I would point out that Hawaii was denying Latinos and African Americans the ability to vote in a state election at the time, but I take your point and I appreciate it.
Thank you. In Griswold and Eisenstadt, the Supreme Court said that states could not prohibit either married or unmarried people from using contraceptives. Do you believe Griswold and Eisenstadt were correctly decided?
So those cases followed from the Supreme Court's recognition of unenumerated rights in the Pearson-Meyer cases earlier. And so what those cases held is that there's a right of privacy.
And do you agree, do you personally agree that these cases, those two cases, were correctly decided? So I'm asking not what the court held, but what you believe.
Right. So so to just go back to Pearson-Meyer, those cases recognized a right of privacy, the ability, one might say family autonomy or privacy, the term under the Liberty Clause of the Due Process Clause of the 14th Amendment.
And with due respect then, Judge, I'm asking, do you agree that those cases were rightly decided?
So I think
correctly
so on Griswold, I think that Justice White's concurrence is a persuasive application because that specifically rooted the Griswold result in the Pearson-Meyer decisions. I thought that was a persuasive opinion. And
do you believe that it was correctly decided?
No quarrel with that.
Do you believe it was correctly decided? Words matter, again, words matter.
Yeah.
Do you believe it was correctly decided?
I think given the Pearson-Meyer opinions, like I said, Justice White's concurrence in Griswold was a persuasive application of Pearson-Meyer. I have no quarrel with it.
So there's a term that actually both Chief Justice Roberts and Justice Alito used, I believe, and affirmed in their confirmation hearings that these cases were correct. And so I'm asking you the same question. Are you willing in this confirmation hearing to agree that those cases were correctly decided?
Well, given the precedent of Pearson-Meyer, I agree with Chief Justice Alito and Chief Justice Roberts, what they said.
That it was correctly decided?
That's what they said.
Do you believe the right to privacy protects a woman's choice to terminate a pregnancy?
That is a question that, of course, implicates Roe v. Wade, and following the lead of the nominees for the Supreme Court, all 8 currently sitting justices of the Supreme Court have recognized that 2 principles that are important. One, we shouldn't talk about, in this position, cases or issues that are likely to come before the Supreme Court or could come before the Supreme Court. And secondly, I think Justice Kagan provided the best articulation of commenting on precedent. She said we shouldn't give a thumbs up or thumbs down.
No, I appreciate that, and I did hear you make reference to that perspective earlier, but you also, I'm sure, know that Justice Ginsburg, at her confirmation hearing, said, quote, this is on this topic of Roe, quote, this is something central to a woman's life, to her dignity. It's a decision she must make for herself, And when government controls that decision for her, she's being treated as less than a fully adult human responsible for her own choices. Do you agree with the statement that Justice Ginsburg made?
So Justice Ginsburg, I think there, was talking about something she had previously written about Roe v. Wade. The other 7 justices currently on the Supreme Court have been asked about that and have respectfully declined to answer about that or many other precedents. It's all the, whether it was Justice Marshall about Miranda or about Heller or Citizens United. And it's rooted, I just want to underscore, it's rooted in judicial independence.
No, I appreciate that, but I'm glad you mentioned that Justice Ginsburg had written about it before, because you also have written about Roe when you praised Justice Rehnquist's Roe dissent. So in that way, you and Justice Ginsburg are actually quite similar, that you've both previously written about Roe. So my question is, do you agree with her statement, or in the alternative, can you respond to the question of whether you believe a right to privacy protects a woman's choice to terminate her pregnancy?
So I have not articulated a position on that, and consistent with the principle articulated, the nominee precedent that I feel duty-bound to follow as a matter of judicial independence. None of the 7 other justices have, when they were nominees, have talked about that, nor about Heller, nor about Citizens United, nor about Lopez versus United States. Thurgood Marshall, about Miranda, Justice Brennan asked about
And
this.
respectfully, Judge, as it relates to this hearing, you're not answering that question, and we can move on. Can you think of any laws that give government the power to make decisions about the male body?
I'm happy to answer a more specific question, but
Male versus female?
there are medical procedures.
Okay, that the government has the power to make a decision about a man's body?
I thought you were asking about medical procedures that
No,
are unique to men.
I'll repeat the question. Can you think of any laws that give the government the power to make decisions about the male body?
I'm not thinking of any right now, Senator.
When referring to cases as settled law, you have described them as precedent and, quote, precedent on precedent. You've mentioned that a number of times today and during the course of the hearing. As a factual matter, can 5 Supreme Court justices overturn any precedent at any time if a case comes before them on that issue?
You start with the system of precedent that's rooted in the Constitution.
I know, but just as a factual matter, 5 justices, if in agreement, can overturn any precedent. Wouldn't you agree?
Senator, there's a reason why the Supreme Court doesn't do that.
But do you agree that it can do that?
Well, it has overruled precedent at various times in our history. The most prominent example being Brown versus Board of Education, the Erie case, which overruled Swift versus Tyson.
So we both agree. We both agree the court has done it and can do it.
There are times, but there's a series of conditions, important conditions, that if faithfully applied, make it rare. And the system of precedent's rooted in the Constitution. It's not a matter of policy to be discarded at whim.
But there's nothing, you and I agree, that prevents the court from doing it, meaning that it is not prohibited. The court is, if I may finish, the
Yes.
court is not prohibited from overruling or overturning precedent. No matter what the steps are that the court must take, the court may overrule precedent. And so my question also is, then, do you believe that this can happen no matter how long the precedent has been on the books? There's no, for example, there's no statute of limitations during which, after that statute of limitations is passed, the court may not touch precedent. Would you agree?
Well, for example, the Supreme Court this past year said that Korematsu had been overturned in the court of history. That, of course, was the case that allowed the internment of during World War II
yes, I'm
of
familiar with
Japanese Americans in the Supreme Court this past term. That was a 1942 or 3 decision in the Supreme
But you'd
Court.
agree there's no statute of limitations. The court can go back as far as it wanted if it believed it was warranted. There's nothing that prevents the court from reaching back many years.
What I would say is there are a series of conditions that the Supreme Court must
I
meet,
agree.
and the age of a precedent, as I think the Supreme Court itself has articulated many times, does ordinarily add to the force of the precedent. and make it an even rarer circumstance where the court would disturb an old precedent.
Thank you. I have a couple of questions for you about voter suppression. Our history, as you know, is littered with shameful attempts to deny voting rights, especially for communities of color, and in particular the African American community in this country. For 50 years, the Voting Rights Act protected against racial discrimination in voting. I know you had this conversation, part of this, with my colleague, Senator Booker. Under the Act, it states that a record of discriminatory voting practices had to obtain federal permission in order to change their voting laws. I know you're familiar with that. But then came the court's decision in Shelby, and by a 5-4 vote, the court gutted the act, effectively ending federal approval requirement. The majority believed that the requirement had outlived its usefulness. As you know, that was part of the ruling, essentially saying that the threat of race-related voter suppression had diminished. So my question is, are you aware that within weeks of the Supreme Court's ruling, Republican legislators in North Carolina rushed through a laundry list of new voting restrictions that disproportionately disenfranchised racial minorities? And it's just a yes or no question. Are you aware of that?
I recall reading about efforts in the aftermath, but one thing I would point out is I believe the Supreme Court's concern in that case was with the formula that was used for which states were covered by the preclearance requirement. I do not believe the court said that Congress was proscribed from going back and redoing the formula. So on the outlived its usefulness, I believe what the court said, I'm just describing it, not saying whether I agree or disagree, was saying the formula had not been updated to reflect current conditions, but was not saying that preclearance was precluded if Congress went back and adjusted the formula and studied current conditions.
Are you aware, as it relates again to that North Carolina action, that the Federal Court of Appeal later held that these restrictions intentionally discriminated against African American voters, targeting them, quote, and these are the words of the court, with almost surgical precision? Are you aware of that ruling?
When was that decision, Senator?
That was, I believe that was in it was shortly after, a few years ago, not 2016.
I'm aware that there's been a lot of voter ID litigation and other voting-related, election-related litigation in North Carolina, in particular, over the last several years. And so I'm generally aware of all the litigation in North Carolina.
And are you aware that Republicans in Texas, Alabama, Mississippi, Georgia, and Florida have also implemented new voting restrictions since Shelby, again, disproportionately disenfranchising minority voters?
Well, I know there's, I'm not aware of the specifics of all that, but I do follow election law blogs and election law updates to keep generally aware of developments in the election law area. It's an area.
Wouldn't you agree then, reading about this on the blogs, that it's troubling? In fact, compounding those with the recent proposal to close more than 2/3 of polling places in Randolph County, Georgia, where more than 60% of the residents are black. Wouldn't you agree that that's troubling?
I'm not aware of that specific, but as I had the South Carolina voter ID case, what I tried to make clear through the trial in that case and the opinion, which was unanimous, that the reality of racial discrimination in America exists.
Yeah.
The long march for racial equality is not over, and that courts must scrutinize efforts to look for discriminatory intent or discriminatory effects. Can always be evidence of an intent, and on certain laws, the effects themselves can be problematic.
And do you believe that the court in Shelby underestimated then the danger that states that was presented in terms of states' willingness to restrict the right to vote?
Well, I don't want to comment on I think that's getting to the correctness or incorrectness of Shelby in particular. I just want to underscore, at least as I recall the opinion, it did say Congress itself could adjust the formula for preclearance, and I don't think Congress has done so, but
And
that's
clearly unwilling to do it. So there will have to be some recourse, don't you agree, for those voters in these various states, if Congress is unwilling to act, to give them due process in terms of equal access to the polls so that they can vote. Otherwise, we're looking at widespread disenfranchisement. Wouldn't you agree, if Congress doesn't act?
So it shall be dealt with the preclearance requirement. There's still, of course, Section 2 of the Voting
Right.
Rights Act, which allows litigation brought by plaintiffs to challenge voting restrictions that are enacted with discriminatory intent or discriminatory effects as well.
Do you believe that Section 2 is constitutional?
I think that's asking me a hypothetical that about any statute.
Because you referred to it, I would like to know.
Well-
I would assume that you think it's constitutional if you think it's a tool.
Well, I think as a general matter, I don't want to pre-commit on any statute that you would identify. If there's some challenge raised, I'll of course listen to the arguments. But Section 2 is an important tool for the voting rights enforcement. The Voting Rights Act of 1965 is one of the most consequential and effective statutes ever passed by Congress in terms, and I've said that, and the history is of course well known, but the voting rates before the 1965 Act were abysmal because of the discriminatory restrictions that were in place, and the immediate effects of the Voting Rights Act of 65 were enormous and are very important for people to understand.
I agree. And in fact, to that point, in his confirmation hearing in 2005, Chief Justice Roberts, when asked about Section 2 and whether it was constitutional, said, quote, "I have no basis for viewing it as constitutionally suspect, and I don't." Do you agree with Chief Justice Roberts that the law is not constitutionally suspect, or do you have a different view?
I don't have any basis for viewing it that way either. I was just, if you ask me about any statute, I want to be careful because I don't know what arguments could come up. And I always want to make sure I've preserved the judicial independence and have not pre-committed. But I agree, I have no basis for doing that.
And then after the president nominated you to the Supreme Court, you had a chance before now, it was the only chance actually before now, to introduce yourself to the American people. You stood in the East Room of the White House and you thanked the president for your nomination, and then immediately you said, quote, "No president has ever consulted more widely or talked with more people from more backgrounds to seek input about a Supreme Court nomination." Now, by my count, there have been 163 nominations to the Supreme Court. So unless you have personal knowledge about every one of these nominations before yours, including who those presidents consulted with and who they talked to, and I can't imagine that you have that personal knowledge. My question is, did someone tell you to say that?
No one told me to say that. Those were my own words. They were based on I did look into it a little bit in terms of thinking about what was possible before cell phones and before phones, and then thinking about the history. And I know some of the history of Supreme Court nominations, and I also know in that 12-day period, I do know that President Trump talked to an enormous number of people. I think President Clinton, when I look back on it, that's why I said no one done more. President Clinton, as I recall, had a consultation process that was very wide as well. But that was my analysis of the situation. Those were my words, entirely my words. And I thought it was important to point out because I was, as I said yesterday, I was deeply impressed by the thoroughness of the process during the 12 days. And I said as much yesterday, and I said as much in the East Room. The 12-day process was, at least it seemed to me, quite a thorough process.
Okay, thank you. And then I'm going to follow up with some questions for the record for you on the first question I asked.
Okay.
Thank you. Thank you. Thank
Senator
you.
Harris.
Judge, as you know, these hearings are a place to hopefully get answers. And as I'm sure you've noticed, your lack of a clear answer to a question I asked you last night has generated a lot of interest. I received reliable information that you had a conversation about the special counsel or his investigation with the law firm that has represented President Trump. As you'll recall, last night I asked you whether you'd had such a conversation, and under oath, you gave no clear answer. Then today, my Republican colleagues raised the issue with you, and again you said you don't recall, and that you had no, quote, inappropriate conversations with anyone at that law firm, which has led a lot of people to believe that that was equivocal in terms of a response. So whether a conversation was appropriate in your opinion is not a clear answer to my question. My colleague, Senator Blumenthal, again asked you, and you said you were, quote, pretty confident. The answer was no. So frankly, if last night you had just said no, or an absolute no even today, I think this could be put to rest. But I will ask you again, and for the last time, yes or no, have you ever been part of a conversation with lawyers at the firm of Kasowitz, Benson, Torres about special counsel Mueller or his investigation? And I asked, were you ever part of a conversation? I'm not asking you, what did you say?
Right.
I'm asking you, were you a party to a conversation that occurred regarding special counsel Mueller's investigation? And a simple yes or no would suffice.
About his investigation. And are you referring to a specific person?
I'm referring to a specific subject, and the specific person I'm referring to is you.
Now, who was the conversation with? You said you had information.
That is not the subject of the question, sir. The
Okay.
subject of the
Well,
question is you and whether you were part of a conversation
The answer-
regarding special counsel Mueller's investigation.
The answer is no.
Thank you. And it would have been great if you could have said that last night.
Well,
Thank you.
Never mind.
Let's move on.
Okay.
Yesterday, Senator Blumenthal asked if you could recuse yourself in cases involving the personal civil or criminal liability of the president. You declined to say that you would. So my question is, could a reasonable person question your independence in cases involving the president's civil or criminal liability?
I'm sorry, can you repeat it one more time?
Would it be reasonable for someone to question your independence in cases involving the president's civil or criminal liability, should that occur?
My independence, I believe, has been demonstrated through my 12-year record, and what you've heard from the people who've worked with me. And I believe deeply in the independence of the judiciary. I rule based on the law, and you can look at cases that I've ruled against when I became a judge, against the Bush administration, and I've talked about the history of our country and the history of the Supreme Court.
And on that point, sir, in particular the history of the Supreme Court and confirmation hearings, Justice Kagan, during her confirmation hearing, committed to recusing in cases she handled as Solicitor General. Justice Breyer committed to recusing in cases implicating his financial interest in Lloyd's of London. Justice Ginsburg refused to commit to recusing in cases that were on her D.C. Circuit recusal list. Justice Scalia committed at the hearing to recuse in a case implicating an issue that was the same as an issue he had decided as a D.C. Circuit judge. So my question to you is, will you commit to recusing in any case involving the civil or criminal liability of the president who appointed you?
Right.
Or nominated you?
The independence of the judiciary requires that I not commit to how I would decide a particular case and to issue a commitment on a discretionary recusal issue in either direction. So if I
Are
answered
you
that
saying it was
question in either
inappropriate?
direction, that would be I would be violating my judicial independence, in my view, by committing in this context. I've explained.
But with all due respect, sir, if I've shared with you that other nominees sitting at that desk or some desk like that have committed to recusing. There have been circumstances where they have committed. So is it your opinion then that they violated some ethical code or rule?
I don't know all the circumstances, but I believe those were situations that were required recusals where they had previously had to recuse and were simply indicating their required recusals. But I don't know all the circumstances. A discretionary recusal is a commitment to get a job, or discretionary non-recusal as a commitment to get a job. Either direction would be violating my independence as a judge, as a sitting judge, and as a nominee to the court.
Okay, it is clear you're unwilling at this point to commit to a recusal, so we can move on. One of your mentors, Justice Kennedy, wrote landmark opinions in the area of LGBTQ rights that have had a major impact on the lives of many Americans. Let's discuss one of those cases, and that's the Obergefell case. In Obergefell, as you know, the court held that same-sex couples have a right to marry. My question is whether the Obergefell case was correctly decided, in your opinion.
Senator, Justice Kennedy wrote the majority opinion in a series of 5 cases, Romer versus Evans.
If we can just talk about Obergefell, that'd be great.
But I want to explain it.
I actually know the history leading up to Obergefell. So can you just please address your comments to Obergefell?
So I would like to explain it if I can. He wrote the majority opinion in Romer versus Evans, Lawrence versus Texas, United States versus Windsor, Obergefell, and Masterpiece Cake Shop. Concluding in Masterpiece Cake Shop, importantly, with a statement, if I could just read this.
But no, please don't, because I actually have read it, and I'm sure most have. My question is very specific. Can you comment on your personal opinion on whether Obergefell was correctly decided? It's a yes or no, please.
In Masterpiece Cake Shop, and this is, I think, relevant to your question, Justice Kennedy wrote in the majority opinion, joined by Chief Justice Roberts and Justice Alito and Justice Gorsuch and Justice Breyer and Justice Kagan, the days of discriminating against gay and lesbian Americans or treating gay and lesbian Americans as inferior in dignity and worth are over.
Are over.
Paraphrasing.
Right. Do you agree with that statement?
That is the precedent the Supreme Court agreed with by a...
Sir, I'm asking your opinion. You're the nominee right now, and so it is probative of your ability to serve on the highest court in our land. So I'm asking you a very specific question. Either you're willing to answer or not, and if you're not willing to answer it, we can move on. But do you believe Obergefell was correctly decided?
So each of the justices have declined, as a matter of judicial independence, each of them, to answer questions in that line of cases.
So you will not answer that question?
Following the precedent set by those 8 justices, they've all declined.
Thank you.
When asked to answer that question.
I have limited time, so
But it's important
forgive me. I'd really like to move on.
Yes.
You've said that Brown v. Board of Education was one of the greatest moments in the court's history. Do you believe that Obergefell was also one of those moments?
I've said, Senator, consistent with what the nominees have done, that the vast swath of modern case law, as Justice Kagan put it, you can't, as a nominee in this seat, give a thumbs up or thumbs down. That's her
Do you think
words.
that Obergefell was one of the great moments in the history of the Supreme Court of the United States?
And for that reason, those nominees have declined to comment on recent cases.
Is it a great moment is what I'm asking you, not to comment on the legal analysis. Do you believe that was a great moment in the history of the court?
So the Justice Kennedy wrote the majority opinion saying the days of treating gay and lesbian Americans or gay and lesbian couples as second-class citizens or inferior in dignity and worth are over in the Supreme Court. That's a very important statement, Senator.
I agree. That's why I think you repeated it. Thank you. Let's move on. Over the last several months, we have all witnessed the inhumane and heartbreaking separation of immigrant children from their families by this administration. Despite a court order requiring the administration to reunite them over a month ago, nearly 500 immigrant children are still separated from their parents. Do you believe that constitutional rights of parents, specifically fundamental due process rights, are implicated in such family separations?
Senator, that is a matter of pending litigation, I believe, and as a sitting judge on the D.C. Circuit or as a nominee, I, of course, can't comment.
Have you watched the coverage of any of these cases on television, or have you read about the experiences those parents and those children have had?
I have seen some television.
In the 1889 Chinese exclusion case, the Supreme Court permitted a ban on Chinese people entering the United States. The court said Chinese people are, quote, impossible to assimilate with our people, end quote, and said they were immigrating in numbers, quote, approaching an invasion. This case has never been explicitly overruled. You've said you'd be willing to talk about older cases. So can you tell me, was the United States Supreme Court correct in holding that Chinese people could be banned from entering our country?
Senator, the cases in the 1890s, as you know,
1889 to be specific.
okay, in that era, reflect discriminatory attitudes by the Supreme Court. Of course, that's the era also of Plessy versus Ferguson.
So would you be willing to say that that was incorrectly decided?
Senator, I don't want to opine on a particular case without looking at it and studying it, but the discrimination
Are you aware that that case has not been overturned?
Senator, I know that with a number of the cases, like Korematsu, let me use that as an example.
Which we've discussed earlier. But
That
on
is-
this case in particular, were you aware that it had not been overturned?
So, Senator, I realize that there's still cases in the immigration context.
Have you ever written about any of those cases and your thoughts about whether they should be re-examined or potentially overturned? And sometimes, obviously, they should be overturned?
Well, there is a swath of cases.
Have you talked about this case ever?
I do not believe. I'm happy to be refreshed if you have something that suggests I have.
No, it's actually a question.
Okay.
And under the Constitution, Judge, do you believe that Congress or the President can ban entry into the United States on the basis of race?
Senator, that was of course, one of the issues that was just in litigation, and there's still litigation about the immigration laws and how
you're not gonna answer
exclusions. That's pending litigation, so I think as a matter of independence and precedent.
Will not answer that. That's fine. Let's move on. In 2013, Texas passed a law that imposed new restrictions on health care facilities that provide abortions. The effect was that after the law was passed, half those facilities closed, which severely limited access to health care for the women of Texas. In 2016, Whole Women's Health was decided, wherein the Supreme Court invalidated the Texas restrictions. Was Whole Women's Health correctly decided, yes or no? And we can keep it short and move on.
Senator, consistent with the approach of nominees.
You will not be answering that.
Following that nominee precedent.
Okay, I'd like to ask you another question, which I believe you can answer. You've said repeatedly that Roe versus Wade is an important precedent. I'd like to understand what that really means for the lives of women. We've had a lot of conversations about how the discussion we're having in this room will impact real people out there. And so my question is, what in your opinion is still unresolved? For example, can a state prevent a woman from using the most common or widely accepted medical procedure to terminate her pregnancy? Do you believe that that is still an unresolved issue? I'm not asking how you would decide it.
Sir, I don't want to comment on hypothetical cases. Roe v. Wade is an important precedent. It's been reaffirmed many times.
So are you willing to
Case-
say that it would be unconstitutional for a state to place such a restriction on women
Senator,
for Roe v. Wade?
You can, the precedent of the Supreme Court Roe was reaffirmed in Planned Parenthood versus Casey, of course, and that's precedent on precedent. And then there are a lot of cases applying the undue burden standard, and those themselves are important precedents, and I had to apply them.
And we've discussed that many times. I've actually had the benefit of sitting through most of the hours of your testimony over the last 2 days. So I
Thank
know
you.
you've talked a lot about that. Can Congress ban abortions nationwide after 20 weeks of pregnancy?
Senator, that's would require me to comment on potential legislation that I understand, and therefore I shouldn't, as a matter of judicial independence, following the precedent of other
Okay,
nominees,
then
do
we
that.
can move on. I'm going to ask you about unenumerated rights. So you gave a speech praising former Justice Rehnquist's dissent in Roe. It's been much discussion about that. And you wrote, quote, celebrating his success in stemming the general tide of freewheeling judicial creation of unenumerated rights. That is what you said in celebration of Justice Rehnquist. So unenumerated rights is a phrase that lawyers use, but I want to make clear what we're talking about. It means rights that are protected by the Constitution, even if they're not specifically mentioned in the Constitution. Right. So they're not in that book that you carry. So what we're talking about is the right to vote. That's an unenumerated right. The right to have children. The right to control the upbringing of your children. The right to refuse medical care. The right to love the partner of your choice. The right to marry. And the right to have an abortion. Now, putting those unenumerated rights in the context of the statement you made, which was to praise the stemming of the general tide of freewheeling creation of unenumerated rights, which means the interpretation there is you were praising the quest to end those unenumerated rights. My question to you is, which of the rights that I just mentioned do you want to put an end to or roll back?
3 points, I believe, Senator. First, the Constitution, it is in the book that I carry. The Constitution protects unenumerated rights. That's what the Supreme Court has said.
But that does not explicitly protect the rights that I just listed, and we both know that that's the case.
Right, so that's point one. Point two is Glucksberg, the case you're referring to, specifically cited Planned Parenthood versus Casey as authority in that case. So Casey reaffirmed Roe. Casey is cited as authority in Glucksberg. That's point two. And point three, Justice Kagan, when she sat in this chair, pointed repeatedly to Glucksberg as the test for recognizing unenumerated rights going forward. In describing the precedent, I agree with her description of that in her hearing.
So thank you for that. So then let's put the rights that I mentioned, which are unenumerated, in the context of your praise of Justice Rehnquist as having stemmed the general tide of freewheeling judicial creation of unenumerated rights. Arguably, every right that I mentioned on that list was a judicially created, unenumerated right. And my question then is, when you praise a jurist who attempted to end those rights, which rights in particular do you believe are praiseworthy of ending?
Right. So that was the test that was set forth by the Supreme Court going forward for recognition of additional unenumerated rights. That was it's cited as authority in that case, Planned Parenthood versus Casey, which reaffirmed Roe.
So let's talk about the right to vote. Do you believe that that falls in the category of having been caught up in the general tide of freewheeling judicial creation of unenumerated rights?
What I was describing with Chief Justice Rehnquist, and it was a description of his career. It was in a variety of areas, and his role.
Specifically, your reference was to unenumerated rights,
Right,
sir.
and in a number of areas. I described 5 different areas of his jurisprudence where he'd helped the Supreme Court achieve what I think has been a common sense middle ground that has stood the test of time in terms of precedent in a variety of areas. At least that's how others have described it. The Glucksberg case, as Justice Kagan explained when she was in this chair, is the case that the Supreme Court has relied on for forward-looking future recognition of unenumerated rights. It
Thank
did
you,
not.
sir. I'm familiar with that. I think you're not going to address the specific enumerated rights, or are you? Because if not, we can move on.
I think I've addressed it. Thank you, Senator.
Okay. In 2011, you were a judge on one of the challenges to the Affordable Care Act. The court you sat upon held there that you dissented on procedural grounds on the court which upheld the act. One of your former law clerks described your opinion in that case, and that's the Seven Sky case, as, quote, a thorough takedown of the individual mandate. He would go on to clerk for Supreme Court Justice Kennedy that year or the next year, and the Supreme Court then held or heard the challenge to the Affordable Care Act, and according to him, your opinion was, quote, a roadmap for the dissenting justices, the ones who would have struck down the Affordable Care Act. Given you wrote the, quote, roadmap, according to your law clerk, could one reasonably conclude that you would have voted to strike down the Affordable Care Act had you been on the Supreme Court?
Couple points, Senator. First, I concluded in one case I upheld the Affordable Care Act against an origination clause challenge. In the case you're referring to, I did not reach the merits, but I discussed the merits that were being argued in both directions. My opinion's been described as the roadmap for both sides because I described both positions. And actually, it wasn't a roadmap at all because I
He
didn't
also
reach.
described it as a takedown.
Well, I speak for myself, and my own opinions speak for themselves. And
It was out of line then, and I'm sure the chairman wants to close this questioning, so we can leave it with that. I thank you,
right.
Judge.
Thank you for your time, Senator.
Senator Harris.
Thank you. Judge, you've spoken about the president's unlimited prosecutorial discretion. Does that discretion allow him to target his political enemies for prosecution and spare his friends?
Senator, in the Marquette speech I gave in 2015, I pointed out that the question of the limits of prosecutorial discretion is a question that's unsettled and needs further study. The Supreme Court, of course, has referred to the concept and well-settled tradition of prosecutorial discretion in Heckler versus Traney and Nixon.
And I actually recall you talking about that during the course of this hearing. And also, I'm reflecting on a conversation you had with Senator Flake yesterday, where he raised concerns with you about a recent tweet by the president. In that tweet, the president attacked the Justice Department for indicting 2 Republican members of Congress because it would hurt the Republican Party at the polls. You said you didn't want to assess comments in the political arena, so I want to ask you to condemn the tweet, even though I believe you should. But would you recognize and agree with the principle that a sitting president should not politicize the Justice Department?
Senator, I think that's asking me to wade into the political arena, and this
So it's not a self-evident.
3 zip codes away from the political arena, Senator.
Okay.
So I'm just going to stay there.
Following up on Senator Booker's question from yesterday on an interview you gave in 1999 in connection with the case you worked on, you said that it was an inevitable conclusion within the next 10 to 20 years, that if the court would say, quote, that the court would say, quote, we are all one race in the eyes of the government. Would you agree that your statement suggests that the government would no longer recognize racial differences? That's my reading of your words, and so I'm wondering, am I in the zone of what you intended?
So I think I talked with Senator Booker about that yesterday. That was
Yep.
certainly an aspirational suggestion, but I have said as recently as a couple years ago that the long march for racial equality is not finished, and racial discrimination is still a reality we see on an all too frequent basis. I've said that in my
Yep.
opinions,
And so I'm going to, and so the conclusion I draw from that is that you would agree, and I certainly believe we have not arrived at that place yet.
there is still racial disparity, racial discrimination, of course, in American society. I've said that in my opinions.
So my question is this: why should it be up to the court to decide when we arrive, whenever that moment comes? Why should it be up to the court to decide?
I think that's a question of how to interpret the precedent of the Supreme Court, and it's different areas, as we've discussed. There's precedent in the higher education context. There's precedent in the contracting context in term.
And does that precedent dictate that it should be the court that would make the decision that we have arrived at that place where we are basically all one race in the eyes of the government?
The precedent doesn't necessarily lead to that conclusion. I think that's an open question going forward. You're familiar with Justice O'Connor's statement in the
Yes.
Michigan case
Yes,
about
absolutely.
25 years, and
Yeah.
that clock is moving fast, but we still have, as I've said in my opinions, work to do.
So I have just a few minutes left, but just to continue this conversation, if it were up to the court to decide, just taking again to the natural conclusion, the comment or what you wrote, will it be the 5 justices then of the court who would decide, or are you suggesting that it should be like Brown v. Board of Education, where there would be a unanimous decision that we've arrived at that point, or could it simply be 5 justices, a majority of the court deciding that we've arrived at that point?
I think a one-size-fits-all answer to the question is hard to give in this
What
context.
do you imagine as being the ideal?
Well, the ideal for every case is that every case is unanimous. But I realize that's naive, but that's the goal, that when I talk about joining a team of 9, that's the goal, and I think that's the goal of every justice. And the court has shown a remarkable ability in some of the most important cases in its history, like Brown versus Board of Education, like United States versus Richard Nixon, to achieve unanimity, and that's part of the reason those cases stand as such landmarks, is
Sure.
the decision, the independence, and the unanimity.
And you and I have discussed that before, and you've mentioned that here. I agree with that. But tell me, when the court does make that decision, if that moment arrives, that we are one race, does that mean the government should not provide federal funding to historically black colleges and universities?
Senator, I think the historically black colleges and universities have, of course, been a critical part of the educational system of the United States. They can,
And partly because we recognize we recognize past restrictions on African-American students being able to have access to higher education. So do you imagine, though, that if we reach this point, that you, I think, hope that we will achieve? I think we all do.
We
which is
all
that we
do.
will all be equal in every way. Do you believe that that would mean then that we would end federal funding for HBCUs?
Again, Senator, that when we reach that point, it's hard to foresee what that would mean. But what I know about the historically black colleges and universities is, of course, the origins of them, that African Americans were denied access to higher educational institutions, what they've accomplished and produced, and they're continuing what they continue to do, and the importance of those colleges and universities in the United States, and will continue to perform that educational function.
Thank you. And how would the courts and agencies enforce laws like the Civil Rights Act of 1964 if the government does not recognize racial categories? I'm not clear about what you're imagining would occur.
Well, that's a question of what Congress has as the law. So long as Congress, and of course a landmark civil rights law, the Voting Rights Act, one of those two, 64 and 65, two of the most consequential laws ever passed by Congress, ban discrimination on the basis of race. And so long as those laws are on the books, and one imagines those laws will always be on the books, discrimination on the basis of race will be illegal under the civil rights laws and the voting rights laws in what they cover.
So what would come of the Civil Rights Act of 1964 in that place that you imagined, at least in 1999, where we'd arrive in 10 to 20 years from then, where we are all one race in the eyes of the government? What would that mean for the Civil Rights Act of 1964? Because I'm assuming that if you are actually confirmed, you will live a long life, as I hope all of us do. And so
Thank you.
it is conceivable that during the course of your lifetime, conceivable, I don't know if it's probable, but conceivable that we'll arrive at that place. So imagining that, and imagining that you will be still a member of the United States Supreme Court, what do you imagine would be your analysis as it relates to the applicability and relevance of the Civil Rights Act of 1964 if we arrive at that place that you describe?
Well, I think those might be two distinct issues, and I think so long, which one imagines it'll always be on the books, the Civil Rights Act and the Voting Rights Act prohibit discrimination on the basis of race in employment, and housing, and voting. So long as those are on the books, those will continue to be enforced by the federal courts, and that discrimination on the basis of race would be something that will be unlawful and illegal.
Thank you. My time is up. I appreciate it. Thank you.
Thank you, Senator.
And then, Mr. Chairman, I'd like to also introduce letters into the record. I have first a letter from several of our nation's leading civil rights organizations signed by the leaders of the National Coalition of Black Civic Participation, the Lawyers Committee for Civil Rights, the NAACP Legal Defense and Educational Fund, the NAACP, the National Urban League, and the National Action Network, all critical of this nomination and expressing concerns. Second, I have a letter from 31 reproductive rights, health, and justice organizations, including Planned Parenthood Federation of America, NARAL, and the National Women's Law Center. And finally, I have letters from the Feminist Majority Foundation, the Disability Rights Education and Defense Fund, the American Network of Community Options and Resources, and the National Center for Special Education. They can be admitted.
That'll be made part of the record without objection.
Senator Harris.
Thank you. Judge Kavanaugh, have you taken a professionally administered polygraph test as it relates to this issue?
No, I'll do whatever the committee wants. Of course, those are not admissible in federal court, but I'll do whatever the committee wants. They're not admissible in federal court because they're
Thank
not
you.
reliable, as you know.
So you've not taken one?
Right.
All three of the women who have made sworn allegations against you have called for an independent FBI investigation into the claims. You've been asked during the course of this hearing by 4 different members, by my count, at least 8 times today, and also earlier this week on national television, whether you would call for the White House to authorize an FBI investigation. Each time you have declined to do so. Now, you know, I know you do, that the FBI is an agency of men and women who are sworn and trained law enforcement, who in the course of conducting background investigations on nominees for the Supreme Court of the United States and others, are charged with conducting those background investigations because they are sworn law enforcement and they have the expertise and the ability and the history of doing that. So I'm going to ask you one last time. Are you willing to ask the White House to authorize the FBI to investigate the claims that have been made against you?
Well, I'll do whatever the committee wants, of course.
And I've heard you say that, but
The witness
I've not heard you answer a very specific question that's been asked, which is, are you willing to ask the White House to conduct an investigation by the FBI to get to whatever you believe is the bottom of the allegations that have been levied against you?
The FBI would gather witness statements. You have
Sir,
the witness statements. They
I
don't
don't want to debate with you how they do their business. I'm just asking, are you willing to ask the White House to conduct such an investigation? Because as you are aware, the FBI did conduct a background investigation into you
Yes,
before we were aware of these most recent allegations. So are you willing to ask the White House to do that? And say yes or no, and then we can move on.
I've had 6 background investigations over 26 years.
Sir, as it relates to the recent allegations, are you willing to have them do it?
The witness testimony is before you. No witness who was there supports that I was there.
Okay, I'm going to take that as a no, and we can move on. You have said in your opening statement, you characterized these allegations as a conspiracy directed against you. I'll point out to you that Justice now, Neil Gorsuch, was nominated by this president. He was considered by this body just last year. I did a rough kind of analysis of similarities. You both attended Georgetown Prep. You both attended very prestigious law schools. You both clerked for Justice Kennedy. You were both circuit judges. You were both nominated to the Supreme Court. You were both questioned about your record. The only difference is that you have been accused of sexual assault. How do you reconcile your statement about a conspiracy against you with the treatment of someone who was before this body not very long ago?
I explained that in my opening statement, Senator. Look at the evidence here, the calendars, look at the witness statements, look at Ms. Kaiser's statement.
Okay. And then, do you agree that it is possible for men to both be friends with some women and treat other women badly?
Of course, but the point I've been emphasizing, and that is if you go back to age 14 for me, you will find people, and not just people, lots of people who I've been friends with, some of whom are in this room today, starting at age 14, women, and who talked about my friendships with them through my whole life, and it's a consistent pattern all the way through. 65 women who knew me more than 35 years ago signed a letter to support me after the allegation was made because they know me and they were with me and we grew up together. We talked on the phone together and we went to events together. That is who I am. What they've said, what the people who worked with me in the Bush White House, the women there. Look at what Sarah Day said in centralmaine.com. Look at what the law clerks. I have sent more women law clerks to the Supreme Court than any other federal judge in the country.
I only have a few seconds left, and I'll just ask you a direct question. Did you watch Dr. Ford's testimony?
I did not. I plan
Thank you.
to. I plan
Thank
to.
you.
I plan to, but I did not. I was preparing mine.